Good afternoon, folks. It's a beautiful day today. We've had some storms, but it's good. Hopefully we won't get kicked off with power losses like we have in a couple of times in the past. We've got a tremendous honor today. Courtney Scollard, attorney at law, who works in conjunction with Family Estate Docs and Asset Positioning Services, is going to do a presentation on DeedWerx, on how to do the quit claim deeds. And she's also going to give us a little extra boon on it. I think she had talked about presenting some information on the unauthorized practice of law so that we don't get ourselves in trouble. But her focus today is going to be on DeedWerx, which is a service that we have through our individual website portals with the Family Estate Docs. So it is she's going to help us with that. So I'm going to turn it over to Courtney, and I'm going to mute myself. Hold your questions till the end so that she can get all the information covered. And then if you've got specifics, we'll take some time to ask and hopefully answer questions. Okay. Courtney, I'm going to turn it over to you.
All right, thank you for that introduction. As Greg said, my name is Courtney Scollard, and I am an attorney in Knoxville, Tennessee. I have been doing estate planning since about 2015, and I have done lots of the quitclaim deeds for the Family Estate Docs trusts and for other services through asset positioning services. I do want to hit on the unauthorized practice of law real quick here at the beginning. Several of the local agents have asked me about this, which is great. They have a healthy fear of crossing that line of the unauthorized practice of law. So as I said, I'm here in Tennessee, and so I'm going to reference some of the Tennessee statutes, but every single state has a prohibition against the unauthorized practice of law, either by attorneys who are not licensed in that jurisdiction or by non-attorney individuals. And so working with estate plans and setting up trusts, you are working very closely with legal services. And so I do want to make sure that, everybody is set up to make sure that they don't cross that line. Pardon me. In Tennessee, and like I said, every state has these laws. You can look them up in your own jurisdiction. The practice of law, according to our statute, means the appearance as an advocate in a representative capacity, or the drawing of papers, pleadings, or documents, or the performance of any act in such capacity in connection with proceedings pending or prospective before any court, commissioner, referee, or any body, board, committee, or commission constituted by law, or having authority to settle controversies, or the soliciting of clients directly or indirectly to provide such services. Now, I know that Randy has talked to you all about how you are not the ones drafting the trust. It's a trust that's been drafted by an attorney. You are assisting the client in entering their information into the system, but it's ultimately the client who is putting in the words. And so the reason you want to make sure that you don't cross that line into the unauthorized practice of law, one, it's against the law. In the Tennessee statute, it is unlawful for any person, either directly or indirectly, falsely to advertise the person or hold out the person as a lawyer. And violation of this section is a Class E felony. So step one, do not tell anyone that you're a lawyer if you're not. The other reason that you don't want to toe this line or don't want to cross this line is that if you are caught in the unauthorized practice of law, whether intentional or unintentional, you can be issued a restraining order, either temporary or permanent, by the courts, and you can be penalized with a fine not to exceed $10,000 per violation. And then there can also be restitution for anyone who has been injured by your actions. And if there's any group of people that's going to figure out how to catch somebody in unauthorized practice of law, it's a bunch of lawyers. So we know how to find those rules. So that was all the technical language from the statute on what the unauthorized practice of law is. But to put it in more layman's terms, things that every person can understand, you don't want to be giving legal advice. The keywords to look for are, what should I do? Don't ever say, I can't tell you what you should do. You should ask a lawyer. If people are asking about their rights, responsibilities, or liabilities based on a document or an action, those are legal questions. Trying to think of any other quick examples. Interpreting legal language. So if there's a clause in the trust that they don't understand what it means, depending on the language of it, interpreting that and putting it into layman's terms could be considered giving legal advice or legal interpretation, especially if it pertains to rights, responsibilities, or liabilities based on that document. So if anybody has any other specific questions about the unauthorized practice of law, two things at the end, feel free to ask any questions. The other thing I would encourage you to do is find an estate planning attorney in your jurisdiction, in your state, in your locality, that you can field questions with, or that you can say, hey, I can't answer this question, but I know an attorney who I can run the question by for you. If you're in Tennessee, I don't mind to field those questions, but I can only answer those questions in Tennessee. Now with that, the segue to DeedWerx, which, as they stated, is something that is available to you through your Family Estate Docs website. Drafting deeds, a deed is a legal document. So depending on the strictness of the state's language, drafting a deed may be considered a legal service. And there are some specific states that only licensed attorneys in that state can draft deeds. So that's where DeedWerx comes into play. If you haven't looked at DeedWerx or are unfamiliar with it, we're going to run through it, and I'll do a sample order on it. But basically, DeedWerx is a website that is a network of attorneys in all 50 states, I believe. And so you input your information with, the property and the trust information, and then they filter it out to someone who is licensed in that jurisdiction, knows all the ins and outs, knows the legal requirements for a deed in that state, in that jurisdiction. So again, if you know of an attorney in your state who is willing to do those deeds, great. Or if you have clients who have property in multiple states, that's definitely an area that this comes into play if you don't have those contacts, in multiple states. So as I said, I am from Knoxville, Tennessee. And if anyone remembers the World's Fair of 1982, yeah, nobody's correcting me. It was hosted in Knoxville, and we built this really cool thing called the Sun Sphere. There we go. There we go. Okay, can everybody see? I can't see how this is. There we go. Okay, so that is the Knoxville Sun Sphere. And it was built for the World's Fair to showcase, cool things that we could do. But for today, what we're going to do is we're going to pretend that our client owns the Sun Sphere and would like to put it in a trust. So with each state, you can find property records in a variety of ways. So when your client is looking to fund their trust with a property, you're going to need a copy of the deed and their certificate of trust. So here in Knoxville, we have what's called KGIS, the Knoxville Global Information Systems. where we can search up who owns any property. So I looked up the address of the Sun Sphere, I popped it in here, I clicked on the owner card, and it brought up the most recent deed. Another way of finding the deed for properties is to go through the tax assessor for the county or for the, or the state's website on property data. Or again, just ask your client. So, all right. Oop, I apologize. I've got little pop-up thingies everywhere. Okay. So when you go to DeedWerx, you'll create your account and log in. And you're going to go and create a new order. And so what we're going to do right now is just kind of walk through the process of transferring a deed or submitting an order to DeedWerx to get a deed prepared for putting into the trust. All right. So you'll enter your contact information on the first page. Your name, the email address that you're going to use for your business, and be checking your phone number, and make sure you tell it that you're not a robot. All right. DeedWerx offers 3 different preparation speeds or processing speeds. There we go. The discount deed preparation costs $75 and will be a minimum of 15 business days or 3 to 6 weeks, depending on how busy they are. The last one I got back from them, they said they were pretty busy, but as with anything, it is going to ebb and flow just depending on what they've got. Standard deed preparation is going to take approximately 2 weeks, 10 business days. That's $125. And rush deed preparation is $175 and is guaranteed within 5 business days. So since this one's just a pretend one, we can pick whatever. And I have done a rush deed with them recently, and it was completed within those 5 days. So once you picked your speed, you're going to select whether you're wanting a quit claim deed, a warranty deed, a grant, bargain, or sale deed, or other. Typically for putting property into a trust, you're going to select that quit claim deed. That's just transferring the interest that your client has in that property and transferring it to the trust. All right, so then it asks, do you have a copy of your current recorded deed? If you have not been able to locate a copy of the deed and your client can't locate one, you can ask DeedWerx to do that deed research. There is an additional fee for it. And you should be able to find the most recent deed, if all else fails, just by calling the Register of Deeds in the county where the property is located. So I've got my deed here for the Sun Sphere, warranty deed from, when is this, 1980. You can go through and see all the information on it. All of that, yay. It's got the recording information and all of that. So I'm gonna download that. Here. All right. So going back over here to DeedWerx, do I have a copy of the current deed? Yes, I do. So I just pop right in here. I don't get it there. There we go. All right, then we're gonna go to, oops, sorry. There we go. So then we're gonna select our property type. Now the Sun Sphere is not a single family home, but oftentimes what you're transferring will be either a single family home, a condominium, or a vacant lot. So for our purpose today, I'm gonna call it a single family home. Okay, your PIN number, parcel number, or tax ID is oftentimes on the deed. You can also call the Register of Deeds or the tax assessor's office to get that information. Let's see. You know what? Let's see here. Where was it? Well, if you don't have it, I think it'll let you go without it as well. Let's try. Yeah, so if you don't have it, then not a big deal. You can still proceed. Does the deed have a postal address? Yes. And it was 810, 810, yep. 810 Lynch Avenue. I can't type today. In Knoxville, Tennessee, 37902. And that's in Knox County. So that's all information you should have from your client, is, the address. If you're dealing with vacant land, it may not have an address. You may just have a parcel number. If it's never been submitted through the post office or the emergency services to have an actual lot number attached. All right, other options that are available through DeedWerx, they can record the documents for you. It's going to be $55 for the recording and $20 for your estimated county fees and taxes. If you are local to the county that you're doing this with, or if your client is, I would not recommend doing this. You can just mail it in. You can call the Register of Deeds, find out how much the recording is going to be, and just do it yourself. There's also the option to complete local city, county, and state forms necessary. Typically, that's not going to be an issue unless your state actually has those. Tennessee, we don't have these forms that are necessary, so there's no reason to spend the extra $45. All right, the purpose of the deed. On this one, we're going to be transferring property to or from a revocable living trust. You can also use DeedWerx for these other purposes, but this is what we're doing today. Do you need to remove a deceased person from the deed? If that applies to your situation, then select yes. Otherwise, you can skip this part. Is it being sold for anything of monetary value? Transferring it to a trust is not for monetary value, since the revocable living trust. The current property owner. All right, we're going to say that I own this property all on my own. I don't, but that's okay. The new property owner, you're going to select that it is a trust and the name of the new owner. So this is where things get a little confusing sometimes, just because, I don't know, this is where I get caught up usually. So what you want to do for the name of the new owner is exactly how it's going to appear on the new deed. So typically on a deed, it'll say, party 1, grants to party 2 this property. And so for this, you want to put the name of the trust, the ABC trust, and then you want to list the trustees' names. Courtney, Scollard, trustee. And then relationship to current owner is going to be trustee, lifetime beneficiary, as long as you're doing a standard revocable living trust. Now, if someone other than the trustor is the trustee, that's fine. You just list their name there. All right, so then. Okay, so tax statements, are they going to be sent to the property address? If the property that you're transferring is the primary residence of your client, then yes. If not, you want to make sure to click no and say that I want it to go to 123 Avenue B, I don't know. So that's where I'm going to be receiving the tax statements. So then, and then make sure you also select with return documents too. They email the document to you, but this is what's going to be on there for the Register of Deeds, where they're going to mail it once they have it recorded and everything. So typically it's going to be yes, use the tax address, but again, evaluate your situation. So other special instructions. If you have anything out of the ordinary that you need to put right here, you can add whatever you need to, or if you have comments. That's really just kind of where you could put anything else that you want the attorney that is preparing the deed to know. There we go. So then you go through there. Then it's going to give you your review, and you have the option to go in and edit things on each of the sections with this. So you can say, I decided I don't need it that quickly. I'll bump down to the discounted processing, or you can go to the faster one. If you realize you accidentally typed in your address for, I did this, for the property owner information, or where was it? Yeah, here we go, the tax address. I got really confused on my first one and put my address in for where I wanted it returned to, because I thought they were going to mail it to me. They don't. It all comes digital. So they will email you a file that has the new deed. They're not going to actually mail you anything, so don't put your address anywhere. But yeah, you can go in and update that right there. Oh wait, wrong address. Here we go, and put in whatever it is that you need to do to correct it. And then you can just go back to your your order details. Okay, so once you have checked this to make sure that everything is correct, especially your property information and the owner information, those are two of the most important things to have on here. Then you hit next. Do you need a mobile notary or not? Yes or no? And I don't know where I would get a gift code or prepayment code. Those would be lovely. But if you have one, great. If not, All right, so then you head into your actual order page. You're going to go in, you're going to punch in your credit card and hit submit, and it'll charge your card. And then you will, you'll be done placing your order. Let's see here. I don't want to actually order this, so let's go to my closed orders. Here we go. I'll go into one here that I did for, let's see, well, when you go to your dashboard, once you're signed in, it'll show you, any orders that you have open. Maybe, I don't know, it's not updating for me. But it'll show you any of your orders, and it'll show you the status of them, so that you can see, if it's in process and all that. And then just make sure that you're checking your email to see when it's finished. Yeah. So that is DeedWerx in a nutshell. And I didn't mention it, but this little blue box here on the side does give you the information, like a little explanation of what you do for each page. And it's mostly intuitive and helpful. There we go. All right, so I guess at this point, we can open it up for questions, because that's all I've got.
I have some questions, Courtney.
Great.
This is Jen Fishburne, and I've done several of these, but I do have a couple questions after your demo here. So on the first page, when you put in the contact information, I'm putting in my contact information, or do I put in the homeowners, or do I give them the choice?
If you're going to be the one handling the deed, and taking it to the client to execute, I would put your information, because that's where they're going to email the deed. And that way you can make sure that, you print it off, you take it to the client, and you say, hey, we have to have this signed and notarized and recorded, because a deed is not effective until it is actually recorded with the local register of deeds.
Okay, so on the county page then, so I do everything on Zoom, and I do them all around the nation. So I'm not doing anything local, and I'm not doing anything in person.
Okay.
So on the county page, then usually what I do when I get to that page is I ask them do you know how to do these? Have you ever done these on your own? Like if they're a realtor or a real estate investor or something, they do them regularly. I let them do it. Otherwise, I suggest that they go ahead and they pay that $45 and have those 2 questions on there to do them, because I'm not going to do that. Right. I'm not
Yeah.
local.
Right.
And I just wanted to know, unless they actually know what they're doing, would you recommend that for a situation like what I?
Yes. Yeah.
Okay.
If you're going to essentially be there holding their hand to go through the funding process, then it's fine to say no. But if they're kind of going to be self-guided in that part of the process, I would go ahead and select for DeedWerx to make sure that everything is already taken care of.
Okay. And so then when they get through, they still have to notarize it.
Yes.
Right. And
Yes.
so once they get it notarized,
Mhm.
then is what is, you said there's one more step?
Yes. Okay. Sorry. Yeah, that was just through the DeedWerx process. A deed is not effective. It's not recognized anywhere until it is recorded with the Register of Deeds in that county where the property is located. So once the deed has been signed and notarized, it needs to be either taken in hand or mailed to the Register of Deeds for that county where the property is located. You can call the Register of Deeds ahead of time to tell them how many pages the deed is, and they will tell you exactly how much the recording fee will be. It varies state to state, but in Tennessee, it's for a 2-page deed, it's $12. So that's not too bad. Sometimes if the legal description goes over, you're going to have to pay a little bit extra for that 3rd page. But you can always call the Register of Deeds, ask them how much, and have the client send the signed and notarized deed along with a check to the Register of Deeds.
So DeedWerx does not do that part.
I believe there was a section that you could ask them to record the deed.
Right.
But it would still have to get sent. I guess the client would then have to send it back to DeedWerx to have them record it.
Okay, so that one question on the county page where the 2 questions for the county, right?
Yeah.
If we could take a look at that, because I want to make sure I got those 2 questions really, dialed in here.
Yeah, give me half a second to scooch back over to that. Sorry, I've got to pop my info back in here. Okay, let's grab that screen again. Share that. Okay. So not this one. Address. We're just gonna say it doesn't. Oh. There we go. Okay, so here, the recording, yes, step 7. Recording service and local forms. I have not used this service, so I don't actually have any experience with it.
So I'm just wondering how this service, because I've always told people to use this service, unless they know what they're doing. I'm just wondering how that connects with getting it notarized. So do they get it notarized and then send it back to DeedWerx, or you just don't know?
I don't know. I'm trying to read here on the blue box to the other side.
I think they had a mobile notary service available for a price.
Yeah, I just saw that too. Sorry to interrupt.
Yeah.
I saw that they have an option for a
Right,
mobile
but that's not,
notary.
but that's that, unless you need a mobile notary, that's not, it's not financially a good use of anybody's money. I don't care how rich, that mobile notary is not worth it.
No. Go
Unless
to the
you're in
bank.
a wheelchair, and bedridden, that's not worth it. So, okay.
Yeah, I mean, well, here, let me click yes and see what it does.
So on this page before you,
Mhm.
if you
Oh,
can
sorry.
just go back.
Yeah, absolutely.
Yeah. On this page, we've got the two options here.
Mhm.
So I guess one is just filling out the forms and then the other is actually recording the documents.
Yes.
And so you said that you don't do the $45 to fill out the local forms. Can you explain why not?
In Tennessee, I have not come across any other local forms that we have to have when recording these quitclaim deeds.
So how would I know that?
I don't know.
I don't want them to spend $45 if they don't need to, but
Right.
I don't want them back and then they don't have the right forms either, and then they're mad at me, right?
Right. And it may be that this doesn't apply for quitclaim deeds because I know at least in Tennessee, there's not a transfer tax when you're transferring into a revocable living trust. And so there's no extra paperwork to have with that. I just don't know what types of local city, county, and state forms they might be referring to, just because I haven't come across them. I can look into that and see if I can
Yeah,
find out.
either that or I'm gonna have to call DeedWerx because that's at
Yeah.
$45 that I need to know one way or the other whether I should be clicking
Right.
the box on this, right?
Yeah.
So that's gonna be important for me.
Yeah.
All right, and can you go ahead and go next then?
Yeah, sure.
All right, and then next, I know this one.
Yeah.
And then next. Okay, now on this page, can you, I know you showed us and I took a screenshot, but
Mhm.
can you,
Oh,
no,
sorry,
not
yeah.
this page, keep going, next one. I know I can
Oh.
do current, it's gonna be the next, it's gonna be the next one, that's gonna be the. All
Okay, the
right,
new
now,
property owner. Mhm.
yeah, the new property owner, okay, so it's gonna be the trust.
Right.
All right, and the name of the new owner, again, is going to be the name of the trust. Now, normally Randy tells us to put the date with the name of the trust. Are we not doing that here?
Oh, you can. Yes. So the full legal name of the trust is going to be the blank 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 trust dated,
Okay.
and put the date of the trust, and then also list the trustees. Yeah.
The trustees. Okay, so
Yes.
all the current, now this is the current trustee, not the successor trustee, correct?
Correct. Only the current trustee. So typically either a single or a married couple, or if you happen to have, I don't know, siblings that are doing the trust.
All right, and then explain the relationship to current owner again, please.
Yeah. Okay. So include beneficial owners of your entity and the percentage of ownership. I believe that this part also kind of goes towards some of the other deeds, but I put trustees, lifetime beneficiaries, because the new owners are the trustees of the trust. The only other option I could really think of would be like self, because it's it's still the same people,
Right.
but it's the trust that owns it.
Okay, and then, and I had just put their names and 100% is what I put.
Okay, yeah.
So I guess there's various things that we could put under that because
Yeah.
it was.
So what's typed here
the,
doesn't actually get transferred directly onto the deed. It's for the preparing attorney to know what that relationship is. Is this an irrevocable trust that has to have a third party listed as the trustee, or is it some other type of thing? So for these purposes, for doing a revocable living trust, you would just list that they're the trustees, that it's the trust of the current owners, something along those lines.
Okay, all right. They want to make sure that you own it, that the people
Yeah.
own it, and that you're not actually trying to put this, whatever your son trust thing, what was,
Mhm.
into your trust, right? Your
Oh, yeah.
somebody else's business into your trust, right? Somebody else's
Right.
property into your trust.
Right,
All
right.
That's what I want to make sure of. Okay, all right. And I can't remember if I had any more. Go next.
Okay, sure.
Make sure.
Courtney, there are two questions in the chat.
Yes.
The first one is Leon asked, aren't there certain circumstances where one may not want to record and deed until the death of the current owner? Would any of those circumstances apply in what we do with our clients?
That is going to be a legal question that you're going to want to discuss with an attorney in that jurisdiction. Yes, there are occasionally reasons to do that. There are pros and cons to doing it that way. A big con would be if the deed gets lost and is never recorded, then it's like it never happened. In that scenario, I would say you would have to discuss it with a local attorney, because it would involve more facts than yeah.
Okay, and then Hale had a question. She said, is it okay if I let my client do the DeedWerx with my guide? They paid with their credit card. They chose the recording service as well. Is that okay?
Oh, yeah, that would be fine. Yeah. The way that DeedWerx is set up is that anyone can use it, because it is a licensed attorney in the local jurisdiction that is actually preparing the deed. So yeah, it's fine if you do it. It's fine if your client does it. Either way.
And then Joe has a hand raised, but I think Jen wasn't finished there.
Oh.
Jen, do you want to?
Did you close out your sample? Because I know you have to start all again. Or...
No. I just took away the screen share.
Okay.
There we go. There we go. All right. So yeah, we were on the new owner, trustee. Alrighty. So then the tax address was the next spot.
Okay, and that's really only if it's like a rental property or something that you're gonna have a different address, right?
Right, if it's not the primary residence.
Okay, and then next, I think we're just about to the end here.
Oh yeah, we were just to the special instructions.
I can't think of any time there would be special instructions. Do you have any?
Okay, let's say it is property that's owned by, let's say 3 siblings. They inherited it and it's owned by 3 siblings. And they've all agreed that they're going to put it into this trust. And so Bob lives in Tennessee, and Susie and Fred live in Georgia. I don't know. So if they're in different states, then you would want to go ahead and note that, like, that there's going to have to be multiple signings by the current landowners to transfer the property, and that you'll need different notary oaths or acknowledgements.
I see. Okay.
Just off the top of my head, that's something I could think of.
So the trust itself, the trust itself is going to be in the county where it's located.
Yes.
I mean and then if there's owners that are, spread out, like siblings spread out.
Yeah.
Okay. So then
so the trust situs is going to be where the client lives, or the trustor lives. So whatever that county is. But let's say, yeah, they own property in another state that they inherited. Then, it's still going to be signed in the state where they live, because that's where they are. but it needs to meet all the requirements of the state where the property is located.
Okay, so now when both trustors die
Mhm.
and the successor trustee
Mhm.
takes over and the property is transferred, then can that be done through DeedWerx or not? Do you know?
They probably can. But
Yeah,
I would
that's-
also check with the local rules on, well, if it's in the trust, yeah, it'll have to be. Yeah, I would say that you should be able to go through here. Oh, hey, I can make that go away. Let's see here. Yeah, oh, what? Yeah, so let's say trustors have died, successor trustee is like, all right, now it's time to transfer this to grandchild A. So now it is that the current owner is a trust, and it's the ABC trust that's going to be transferring it to an individual. The name of the new owner is grandchild A. And the relationship is beneficiary, because grandchild A is a beneficiary of the trust who is the current owner.
Okay, now this is making sense.
And so, and again, here with this, it would be that, form of ownership, the trust is the sole owner. You don't have to worry about these other ones. And then you go through there.
Okay,
So yeah.
all right. Since it's something we're already familiar with, it makes sense that we would do it on that end as well.
Yeah. There we go.
Okay, thank you so much for all of your help. I really appreciate it.
Yeah, you're welcome.
Joe Amaro still has a question.
Yeah. My question pertains to this. Okay, I'm kind of starting to do this, the trust program, and I have a situation at hand where this lady doesn't want to do the trust until she gets her home into the trust. And I told her, you got to do the trust first. Well, she told me she has a mortgage on the house, and this is a thing that I'd like to go over with. How do you get the mortgage into the trust? Because she's telling me that she was told by the bankers and also one of her friends who is not a lawyer but has friends that are lawyers, that, and she had similar situations. She said that in order to do the mortgage thing, that she has to go see the lawyer to do that, to transfer a mortgage, because of the mortgages thing. And also she was saying that certain banks could actually decline having the mortgage put into the trust. Is that possible? Can you explain all these, because it's so confusing?
Yeah, so the mortgage is different from the title to the property. A mortgage is actually a lien on the property. It's a secured debt. And so the mortgage company does not actually have title to the property. They have, well, it's, okay, that's a whole other complicated thing. But basically what it is that the titled ownership of the land is the individual. The mortgage is a separate document. Now, yes, if you do a title search, it will show that there's a mortgage on the property. But I don't know of a reason to transfer the mortgage into the trust, because the mortgage is the contractual relationship between the bank and the borrower, the owner of the land. Now, what they may have heard about is that most mortgages do contain an acceleration clause, where if you ever sell the property or transfer the property, then the bank, the mortgage holder, has the option to accelerate the loan and call it due in full immediately. That's because a mortgage is a secured loan, and so it's your land that you're putting up as security that you will pay back this loan. And if you transfer your land to someone else, then the bank still has a claim to it, but you're not affected if the bank asserts their claim and forecloses on the land, because it's not your land anymore. So
Okay.
it's not really, it doesn't secure your debt anymore. And that's why they have that acceleration clause. Now, transferring the property into a revocable living trust, it's not actually changing ownership. And so I have not come across any mortgage companies that have had an issue with, transferring a mortgage property into a revocable living trust, because it is still tied to your social security number. It's still, you're still the one living there. You're still the one who, has the investment in the land. But in theory, there could be a situation where, a mortgage company would attempt to accelerate a loan based on the transfer. Whenever people are concerned about it, I just recommend that they call their mortgage company and say, hey, I'm setting up a revocable living trust and I want to put my house into it. I just want to make sure it's not going to cause any issues with my mortgage. Did that answer your question? Sort of.
Yeah, I'm confused. This is also anything that I say as far as this goes, right? It gets into lawyer land, right? If I was to say stuff like what you're telling me to the client, is that
You can
starting
definitely
to
tell
get
them, call
into?
your mortgage company and ask them. Yeah, I mean, I would not recommend getting into the discussion of the difference between, a warranty deed or a quitclaim deed, the ownership deed, and the mortgage, which is a deed of trust. I would not recommend getting into, because I worked in that for about 7 years and still I'm not fully comfortable talking about it. Just because there are lots of ins and outs to the difference between all of that.
Yeah, because I'm in Hawaii,
Okay.
and over 50%, I would, from what I've heard, and I think this is true because everyone I've talked to, because the cost of living is so high, everyone's remortgaged their homes and stuff, and
Yeah.
ev pretty much like every one of my friends, I'm shocked. Okay, I was shocked when I just talked to people in general. They've remortgaged their houses at age 50, 60. Even this guy I picked up, right, as a client of mine for the trust, created one for, I'm doing a restatement kind of thing, He has his house is on remortgage too, and he's like 70
Two.
or 80, or somewhere around the 80, 81, 82.
Yeah.
And he still has another 16 to 20 years on his mortgage kind of thing, that he got.
Yeah.
So, but they were able to get his house into a trust, his
Mhm.
house, the original, he got his trust created in 2021.
Mhm.
I'm doing the restatement because the cost just to step in the lawyer's office is $900
Mhm.
just to step in the office. So the lawyers told him, before you step in my office, you better have all the questions, everything said, because we're going to
Yeah.
charge you 900 plus their fees as well as for all the stuff they're going to do as well. So he was shocked. So when I talked to him about that, he asked
Oh,
me
wow.
out of the blue. So that's why. But the thing is, okay,
Mhm.
so it's possible. What would be the procedure then to do a home that's mortgaged to put it into the trust? Because it's different than putting a a a home that's owned already, 100% owned with no mortgage, right? And that's what you were talking about to begin with.
Well, no, so when you, let me pull this back up. So like this is a warranty deed, which is typically going to be, what you've got that shows the ownership. So when somebody buys a house, they get the warranty deed, but then they also have a copy of the deed of trust, which is the mortgage. And so what you're doing is you're transferring the interest from this warranty deed. And also a quitclaim deed is different from a warranty deed in that a quitclaim deed only transfers whatever interest you have in the property to whoever you're transferring it to the trust. So if it's still mortgaged, then you have 100% interest in the property as the property owner. The bank just still has that note on it that says we have to get paid or we can foreclose on it. So you would still go through the same process with DeedWerx, getting the current warranty or quitclaim deed, whatever's recorded with the county's register of deeds. and you would have DeedWerx prepare the new quitclaim deed based off of that deed.
Okay, so it'd just be basically treating it like a regular transference from the I guess the vested person's interest that the person that's making that purchase, the owner, quote
Yeah.
owner, into the trust. And
Right.
so the procedures would all be the same.
Yeah.
Okay. Also, you mentioned that before you do anything, would it be wise to ask the mortgage company if there's an accelerated clause in there? How would they know if there's an accelerated clause in their contract or not?
They're pretty standard in mortgages, but they could just call the customer service number on their mortgage statement. They may have to accelerate it up to a supervisor to actually be able to get an answer. But yeah, they should be able to just, or their lending officer at their bank. They could just ask them.
Okay. Yeah, because that's their concern as well, because they're afraid to do anything with and that lady told me, if I'm not gonna move my house in a trust, why should I have a trust? And I'm trying to
Yeah.
I messed up in that sense on that, but it's like she's kind of, like I guess she's heard the nightmarish stories. I checked on the internet and they also said there's some kind of law, federal law stating that the mortgage companies are required to allow a home to be put into a trust even if there is a thing on it without accelerating. So that's why, see, that's the conflict, right?
Okay.
I've heard it. Okay, so all I know is
Yeah.
I've heard, or actually
Yeah,
I've
yeah.
seen on the internet. So what
Yeah.
is true and what is not?
Right. You'd have to look at the rules in your locality, but if you see in the chat Jay's comment, and I can absolutely agree with this. To be honest, most banks don't care anyway, as long as the payments keep coming in, and that is true. If the payments are coming in, they don't really care who it's coming from, as long as it's not the mob.
And
Okay,
I
but
will say,
still,
Joseph, that
yeah.
I had talked to an attorney, and there are actually two. This is from the attorney, that's why I can say this. There are two federal laws that protect owners of primary homes. So this is for an owner's primary home, for it to go into a revocable living trust, that the mortgage company can't do anything about it. They can't do their due on sale clause. They can't add extra fees or anything like that because the revocable living trust is essentially them. There's no sale actually happening. That's why, when you mention to people that you're putting it into the trust, you don't have to worry about them paying sales tax on it because they're not actually selling the home. Now, in the case of something other than a primary home, that'd be a case of contacting the mortgage company and make sure that they're not going to do a due on sale clause. But in most cases, they're not. It's become pretty, like 20 years ago, it used to be the case that mortgage companies were more likely to do a due on sale clause for putting into a revocable living trust. It's not as common nowadays, but that's what you'd have your client confirm with the mortgage company to make sure that, they wouldn't call the note due.
Okay. Okay, thanks.
Mm.
That answers it for me. Thank you.
Okay,
welcome.
All
super.
right, great.
Joe, thank you. Lisa, is there any other questions out there?
Nothing more in the
I have a
chat.
couple questions.
Okay.
Go
Cynthia,
ahead, Cynthia.
Hi. Should we put timeshares in the trust?
Oh, I'm gonna give you my straightforward great attorney's answer. I don't know. Timeshares are kind of their own little universe that I have not taken the dive into. I know that so when you say timeshare, are you referring to you're referring to like where you own 2 weeks of the condo in Florida, right?
Yes, yes.
Yeah, so you don't actually own the condo. You only own the right to occupy the condo for those 2 weeks.
Okay,
I don't know. I have
Okay.
not looked into that.
okay. And my other question, can't a person go to the local where they live and get the instead of, if I don't do the deed work and they didn't want to do it, they can go to the local registrar's office and get the property taken care of.
Well,
Correct.
someone still has to draft the deed transferring the property. They can go to their local register of deeds and get a copy of the most current deed. But there still has to be, that's going to show, let's see, like on this Sunsphere one, excuse me, it's going to show that Judith Overholt Moss gave Knoxville's Community Development Corporation, that property.
Okay.
And so what you want to do with putting it into the trust is you want to say Knoxville's Community Development Corporation has now transferred that property to the ABC Trust.
Okay.
So
All right, I
there
see what
still
you're
has to be
saying.
a deed to do the transfer.
Okay. Got it. All right. Thank you.
Yeah. Ah. All right. Jay has said that he knows you can put a timeshare into the trust. I would mention that a timeshare is an asset, and if you want the asset to avoid probate, then it should be in the trust. Yes, definitely. And I just don't know how you change the title on it because I'm scared.
I think that was an option in sort of blasting through it on DeedWerx, is that there was a timeshare component there. The type of property was commercial, residence, timeshare. So yeah, you can click on that and
Thank you.
Any
Jay
other
had a
questions?
Jay had a question in the chat. It said, is reviewing someone's trust documents to ensure it covers their wishes crossing into the territory of being an attorney? Does the answer change if it is not charging for the review?
All right. It's a gray area. If you're reviewing so like if somebody already has a trust or a will or whatever, and you basically just read it back to them and say, okay, your trust says, and you read back, Bobby gets, 10% of my estate. Susie gets 10% of my estate. I'm running out of names. Let's see here. We got Eddie. I'm just looking at whoever's on my screen here. Eddie gets, the house. And then Joe gets $750 on the car. I don't know. You can read that back to them and say, okay, does that sound like what you want your estate plan to do? Because that's what you have written. In that scenario, I would be sure to tell them that it does look like there's only 20% of their estate given away, because I can't math right now. So if you're not interpreting what it says, then I think that would be fine. And you can, that can also include like you're drawing it out and it says, okay, it goes to my children in equal share. You say, okay, well, who are my children? And you write down their names. And so then you count how many kids they have and you say, okay, equal shares. That means that this one's going to get 1/3, that one's going to get 1/3, and this one's going to get 1/3. You're not interpreting anything right there. You're just, I guess you're just putting it in a different format for them to be able to see and make sure that it does align with their wishes. Now, if they start getting into any legal terms, should this be per stirpes or per capita? What does that mean? Ask an attorney. Or, I want to make sure that it does this, this, and this. And if it's not clear, like just with a plain reading of it, that's where I would say that you should, refer it to an attorney. Does the answer change if you're not charging for the review? So definitely if you are charging for the review, any sort of interpretation would be a big no-no. If it's not, as do what you're comfortable with, but always preface with, I'm not an attorney. I can't give you legal advice. This is what it sounds like it does to me. And always put in the default of, if you have more questions, you should probably check with an attorney.
So is
You
it
know,
good to
it's one
have
of the
something in
things.
writing then like that? Oh, sorry.
Who, what, where?
Go ahead, Joe.
Okay. So therefore, is it good to have like my boss is not in this in the Fed, but he told me it's good if I have something in writing that I give to the client and they sign as well, stating that, I'm not a lawyer, and then, the recommendations I give to you are such. So every time you meet with them, date it, and then just give them, just have them sign at the bottom afterwards. And then you keep a copy, they keep a copy, he said, and that way too, and then also give a recording of the minutes or whatever went on. So therefore, because I already had a total misunderstanding with a client that they told me, I told them this at the meeting, and then the next time I went to meet with them, they said, I said this, and I said, no, I didn't say that. I said, what I meant to say was this, and this, and they said, no, you didn't. You said this, and so therefore, I talked to my boss on that, and he says, no. At the end of each meeting, just do an email to the client and just tell them this is what went over the meeting. If you have any questions, you can call me.
Absolutely.
Because
Your free legal advice of the day is always, always, always get it in writing. And yeah, if you've had a verbal conversation, especially a phone conversation with somebody, and have like negotiated out terms or things that you're going to be doing or providing or things like that, yes, it is always best practice to get that in writing. And yeah, doing a disclaimer, especially
Yeah.
like with your engagement letter or however, they hire you. Or even just with that initial meeting, just a disclaimer that says, I'm not an attorney, I'm not providing legal advice, I can give you financial advice, I can tell you what I would do, but that,
So-
and put in there like, and you're always welcome to consult an attorney.
Yeah. So basically you're doing a memorandum of understanding. For, this is my understanding of what we had conversation wise today. And then, sign it, date it, and send it to them. And then, it's not an opinion, it's just, I understand that, boom.
And when
So-
someone buys a trust from you, you have them sign the interview certification, which I added in the chat here. That's a standard document for any family estate doc sale, and it says that sort of verbiage on it. They are acting in a clerical capacity, not as a lawyer.
That's part of the EULA, right?
No, it's a separate document. But
separate
in
document,
the
okay.
in the EULA it definitely specifically states that for sure. And I also, for my clients, when I don't have them, when I'm just doing everything paper and I'm not having them click the accept button, I print out the EULA and I have them initial every page and sign and date the last page.
Good idea. Good
you have
idea.
them sign every single page. I just have them sign the last page.
All up to you. I prefer them to just
Initial.
more cover your hiney.
It,
That way
it's an
they-
acknowledgement that you've covered each separate page.
Yeah,
They might have
especially
said, "No,
since
you only gave me the last
especially-
page."
yeah,
Sorry.
especially since the EULA, it was made mainly for someone to hit accept online. It's not really made for printing, so it doesn't include a page 1 out of 6, 2 out of 6, or anything like that at the bottom. So that way you know that it's each page is in there. I don't know, that's what I do. Do what you're comfortable with.
So,
Okay,
well, this has been a
thanks.
tremendously informative session. A lot of good information covered. Everything from the unauthorized practice of law to how do we get a quit claim deed done quickly or not quickly, depending on which option you choose, how much you're willing to pay for. So are there any other questions out there? Okay,
Nothing more in the chat, Greg.
okay. For those of you who are still here next week, one of the topic we want to cover is Jeff Mills, and it is a pre-recorded webinar. Jeff Mills is going to talk to us about doing workshops. And I know Randy has talked about this a lot over the past couple of months. He said, you know, it's as easy to do it to many as it is to do it to one. And it can tend to be very profitable. So that just to give you an idea of what we're going to talk about next week. And we will see you all then. If there are no other questions, we can say adieu. Okay?
Great. Thanks
Thank you,
so much.
Courtney.
All right,
Thank you,
thank you all for
Courtney.
having me.
This is the best information I had on this, more, the house, because that's basically what every, a lot of people here, especially in Hawaii,
Yeah.
they're cash poor, but real estate, because just the home
Yeah.
by itself is over $1 million here.
Yeah.
And so with that, that's why they remortgage their place, like I said earlier.
Yeah.
And that helps the seniors to survive here.
Yeah.
And so, but the information you gave is gold.
Yeah.
Gold
Hey,
and
I would
platinum.
recommend
Thanks.
find some real estate attorneys or call title companies that are in your area, and see if you can strike up a relationship. I have a couple of title companies that I keep, their number in my back pocket so that I can ask them those questions. Whenever I have specific questions that require a little more specialty. But yeah, form a relationship with a real estate attorney or a lending, maybe find somebody in mortgage lending, just to kind of expand your network of experts so that you have somebody local that knows the Hawaii rules and regulations and everything, and take them out to lunch and pick their brain.
Yeah, sounds good. Thank you.
Yeah,
Appreciate
absolutely.
it.
Okay. Well, you all take care. Have a blessed weekend or week. This is just Tuesday. It is not the weekend yet. So we will talk to y'all later.
Wonderful.
Take care.
Thanks so much, Greg.
Wonderful.
Thanks, Courtney. Bye.
Yep.
Bye-bye.
Thank you, everybody.